and welcome to this Judicial Candidates Forum, co-sponsored by the Cleveland Metropolitan Bar Association, JudgeForYourself.com, and the League of Women Voters of Greater Cleveland. I'm Catherine LaCroix. I'm the co-president of the League of Women Voters of Greater Cleveland, and I will moderate. The candidates in this forum are Kenneth Callahan and William Vodrey. Our candidates are seeking a 6-year term on the Court of Common Pleas General Division. This court has general jurisdiction to hear civil cases where the claim is more than $15,000. So property, contract, personal injury, other types of civil claims. These are what you think of when you say, I am going to file a lawsuit and go to court. Also, the court has very important jurisdiction over felony criminal cases. In order to qualify to be a judge on this court, a person must be an attorney admitted to practice of law in Ohio and must have had at least 6 years of experience in legal practice in this state. So the procedures we will follow are relatively simple. I will start the questioning by randomly choosing a candidate to speak first. After that, we will rotate between the candidates for who answers each question first. I'm using a list of questions prepared in advance. I regret that due to the short time period for this forum, there will be no additional questions from the audience. Each candidate will have 1 minute to answer each question, except for some of them are 2-part questions, and I will tell the timekeeper to allocate 2 minutes for those questions. There will be no rebuttal. We have a timekeeper who will display a card with a 10-second warning and then a second card to stop. I will ask as many questions as we can to fit into the 1/2 hour that has been allocated for this forum. Are there any questions from any of our panelists about the procedures?
Just one quick question. What's the length of the process?
We have 1/2 hour for this forum.
Okay.
List of questions that should consume that time.
Very good. Thank you.
Thank you.
And now this is, where is it? I got to get into the screen. This is difficult with the virtual background. Well, I'm holding up a mug, which contains slips of paper with names in it. Okay, so I'm randomly, you can't see it because the virtual background, but I am randomly choosing a slip of paper from the mug, and I have the name of Mr. Kenneth Callahan. So the first question, the first answer will be Mr. Callahan. So, Mr. Callahan, what work or other experience have you had that you believe will particularly qualify you to perform the duties of a judge on this court? You have 1 minute.
Thanks very much. I think first and foremost, I had the opportunity to serve as a common pleas court judge in this community for 16 years. I was originally appointed by then Governor Voinovich to fill a vacancy in 1993, was elected in 1994, elected in 1996, and reelected in 2002. I served on the bench till 2009 when I retired voluntarily to return to private practice. During that 16-year tenure, obviously I had an opportunity to be well acquainted with the various processes of the court, the criminal and the civil docket, and have in the time, both concurrent with my judicial service and as a lawyer, been involved with a lot of civic and legal matters.
Okay, thank you. Thank you. Mr. Vodrey, what work or other experience have you had that will particularly qualify you to perform the duties of a judge on this court?
Thank you, Catherine. And first, let me thank you and the CMBA, Judge for Yourself, and the League of Women Voters for sponsoring this forum. I'm a proud member of both CMBA and the League of Women Voters, so it's great to be here with you. For the last 18, going on 19 years now, I've been serving as a magistrate of Cleveland Municipal Court, doing the hard work of a judicial officer, determining guilt or innocence in criminal cases, liability in civil cases, handling sentencing, giving people a second chance whenever I can, imposing jail time when I think I must. Many judges go their entire careers without ever actually having a case officially reported as Ohio precedent. I've had 21. And what I'd like to do now is to bring my experience, my skills, my passionate commitment to justice to a higher court to be of service to the entire community.
Thank you. Thank you, Mr. Vodrey. You then, as we alternate answers, are the recipient of my second question. So, Mr. Vodrey, and this one is a 2-minute question. Do you believe that all citizens have adequate access to legal help and the legal system? Why or why not? And if not, what can be done to make it better?
That's a great question. Unfortunately, they do not. The promise of equal justice for all is still illusory for too many people in American society. Back in the 90s, when I was a lawyer with legal aid down in Tuscarawas County, the Spangenberg report identified roughly 2/3 of people with civil cases, civil unmet legal needs. And unfortunately, for all the work, for all the time and effort that's gone into addressing that gap, it still remains quite large. I'm proud to be a member of the Cleveland Legal Aid Society, which is doing great work along those lines, but it often comes down to money. We need more money into the system so that people get the help that they need. There are so many cases I saw as a legal aid lawyer, as an assistant county prosecutor appointed by the late Stephanie Tubbs Jones, and now as a magistrate for almost 19 years, where people really would have benefited from the help of an attorney. We all know lawyer jokes. I've told a few myself, but often a lawyer can make the difference between a good outcome and a bad outcome in civil cases. Of course, in a criminal case where you might go to jail, or in a capital case, even lose your life, you are entitled, since the Gideon decision, to have a lawyer provided to you at no cost. But there's a vast unmet need for civil legal assistance in this country, in this state, and unfortunately in this county. And if I had the honor of being elected to the Court of Common Pleas, I'd want to do all I could to encourage lawyers to get more involved, to provide services pro bono, and to work closely with civil legal aid providers to see that those services were provided wherever possible. But there's a long way to go yet, and I hope to be part of the solution and certainly not part of the problem.
Thank you. Mr. Callahan, the same question. Do you believe all citizens have adequate access to legal help and the legal system? Why or why not? And if not, what can be done to make it better?
I agree that adequate representation is not uniformly available to all citizens in this country and in this community. On the criminal docket, as was pointed out by William, since the Gideon decision, criminal counsel at the trial level is required under the Constitution, and everybody charged with a felony in this county will have a trial, will have an attorney assigned to them, both in the Common Pleas Court as well as in the federal district court. But the civil is more problematic. I think that there simply is not probably enough economic resources to adequately help people that have civil problems, whether it's divorce or it's probate or it's an injury case that people in higher economic and social backgrounds will have access to. People that do not have access to those economies will not have. I think that there is a great effort by legal aid to try to fill that gap. I think the trial courts are kind of obligated to help an unskilled pleader, somebody that files a case pro se, for example, and is required to, it needs help in the litigation. Then I think the court's got an obligation to try to help those people. I've volunteered for a long time at the Cosgrove Center to counsel the homeless, and I thank you.
Okay, thank you. Mr. Callahan, you are the first recipient of the next question. what are your views as to whether the court system as a whole deals effectively with racial, ethnic, and gender bias, and how can it do better? You have 1 minute.
Thank you. Well, I mean, I think that in the first instance, the answer is, as a trial judge, and I said this in different formats this morning, but as a trial judge, you are really only responsible for the 4 documents of an issue before you. So as a trial judge, it is very incumbent on that person to listen very carefully to people of color, to listen to their stories, to make sure that they're being treated the same as any other litigant before the court. In a systemic way, these are large questions that I think probably need to be addressed in a large systemic way. And in terms of gender bias, the same thing. I mean,
Mr. Callahan, I'm listening. Would you like, the stop is up. Would you like an additional minute? Because I'm realizing this question deserves a little more. Would you like an additional minute? Make this a 2-minute question.
well, it's very thank you. I'll try not to take the whole minute, but I think that the answer to the question is, to the extent that it's individual, I think the individual has got an obligation to listen to people that come before the court and use his very best efforts to address all people, regardless of gender or race, equally. But in a larger systemic sense, I think we're seeing efforts at police reform in this community. Judge Oliver has the consent order, which is designed to help reform and help bring to discipline, police officers who don't follow the rules. And I support those efforts to. And we can always, the thing about the Justice Center, it's never perfect. It's always going to require best efforts and continuing efforts to try to fill gaps.
Thank you. And I apologize for changing the time limit on you. It just dawned on me as you were answering. No, this was an important question that deserved more time. So, Mr. Vodrey, what are your views as to whether the court system as a whole deals effectively with racial, ethnic, and gender bias? How can it do better? 2 minutes.
Thank you. It certainly can do better. It's every judge, every magistrate's absolute ethical duty to see that justice is done without fear or favor, bias or prejudice. And that's what I've strived to do for 18, going on 19 years now as a magistrate. It'll be 19 years next month. And that's what I would continue to do if I had the honor of being elected to the Court of Common Pleas. Everybody who steps into a courtroom in this country should be confident, as too many are not these days, that they will be treated fairly and impartially, that no irrelevant factors such as the color of their skin, their sex, their ethnic or national origin, their religion, or anything like that would be considered as a factor. In 18, going on 19 years as a magistrate, I have never, even with very angry people standing in front of me, been accused of deciding a case on anything other than the facts and the law. And I'm very proud of that record. I've had people come in and say, it doesn't matter what I say, you're going to convict me anyway in criminal cases. And I'm at pains to say that's not so. I'm here to see that justice is done. Those aren't just words on a page. Those are an absolutely vital concept in American law. And I believe police officers. I've disbelieved police officers. I believe criminal defendants. I've disbelieved criminal defendants. Every case needs to get the time and attention it deserves. And everybody who comes in my courtroom can be and should be confident that justice will be done. Now, we're all human. We're all aware of the concept of unconscious bias, something that all of us should strive to overcome, not just judicial officers, but everybody in American society to build a better country. But being aware of that and striving to see that justice is done is something that I take extraordinarily seriously and something I want to continue if I have the honor of being elected to the Court of Common Pleas.
Thank you. Well, then I think we will move on to the next question. And Mr. Vodrey, for you, what do you believe to be the appropriate role of courts in our political process distinguish, if for our audience, if you will, between the judicial system and other elected offices?
Certainly. We live in a democracy, and Ohio, like a majority of states still, I think the count is still 34 states still do elect judges. So the process will be inherently political, at least on some level. I'm running as a Democrat, and I'm proud to be one. Mr. Callahan has been appointed by the county GOP Central Committee and is running as a Republican. You will not see a party label after our names on the ballot, but it is who we are and the parties that we come from. We have a hybrid system in Ohio. We have a partisan primary, a nonpartisan general election, especially at a time when we have a Republican president who routinely attacks an independent judiciary, who routinely insults judges, calls them so-called judges, referred once to a Mexican judge, such that the Chief Justice of the United States, himself appointed by a Republican president, felt he had to step in and say, that's wrong. That's not the kind of independent judiciary we want to have. So in the day-to-day work of the Court of Common Pleas, there is no space for politics, but how we select and elect judges is going to be inherently political. Thank you.
Mr. Callahan, then, same question. What do you believe to be the appropriate role of courts in our political process? And please distinguish between judges and other elected offices.
Well, I think in the larger sense, you need to remove politics to the extent that we're able to do so from judicial decision making. You know, as a distinct branch of government, we should not be infected by the perception of the public that we're making decisions based on politics. There's a reason the common pleas races are nonpartisan, because you cannot make a commitment to political issues because you're a judge. And I think it's important that the judiciary to maintain its independence, be as free as humanly possible from political considerations.
Thank you, Mr. Callahan. The next question is somewhat related, I think. So how do you believe we can assure that judges are independent of special interests? Please discuss campaign contributions and third-party electioneering. One minute.
I'm sorry, could you repeat it? Because I think there was two parts.
Sure. Yeah. Okay. Make it 2 minutes. How do you believe we can assure that judges are independent of special interests? And please discuss campaign contributions and third-party electioneering.
Well, in terms of special interests, I don't think that is a large component of local trial court races. I mean, I think the special interests are implicated more in appellate court and certainly at the Supreme Court level than they are at the trial court level in our county. And I'm not sure what the allusion is to third-party contributions, but you know, there's not many special interest groups or big political groups that typically get involved in a fundraising level in local common pleas court races. So I think it's a problem as we climb the ladder on the higher courts. I really don't see it as being a palpable problem within the trial courts.
Thank you. Mr. Vodrey, how do you believe we can assure that judges are independent of special interests? Please discuss campaign contributions and third-party electioneering.
It is vitally important that judges be perceived as independent, that as the Ohio Supreme Court once said, that justice is not only done, but that it's seen to be done. Unfortunately, when we elect judges, we inherently make them, at least on some level, politicians. And Ohio voters have been asked in the past if they wish to go to some form of merit selection. I know Ken and I would both support that, depending upon the details of the proposal that was put forward. But Ohio voters have resoundingly said several times in my adult lifetime, they like electing judges, and that seems to be the system we're going to have for the foreseeable future. Anybody who comes into a courtroom should be confident that their cause has not been prejudged. Ohio law wisely prohibits judicial candidates from saying, I will always rule this way, or I will never rule that way. You would not want to go into a court knowing just through a little Googling that the judge before whom you were appearing had already said, I'll always do things this way or not that way. Everybody who knows me, who has seen my work over the last 18 going on 19 years, knows that I'm fair and impartial, and third-party interests would play no role whatsoever in how I approached any case.
Okay, thank you. Next question, going in the first instance to Mr. Vodrey. What have been the most effective methods in recent years for improving court procedures for efficiency? And what other methods might you suggest for such improvements?
That's a great question. Well, we're all sort of learning our way in this COVID-19 era, using Zoom and doing perhaps more by phone than we would have otherwise. I would want to encourage that continuing process, but there really is no substitute, especially in jury trials, for having people gathered in a room, even a very large room with appropriate social distancing and masks. But the jury system, as vital as it is to American democracy and the rule of law, was not designed for a pandemic era. The Court of Common Pleas is about to begin jury trials. I hope it works. I have to admit I'm somewhat skeptical that it will, and it will unfortunately only take one sick juror or one sick witness for the system to come screeching to a halt. But we have to do our very best because people are entitled to jury trials in many cases under a system of justice. Wherever possible, though, we ought to be, both for convenience and safety, be giving people the opportunity to appear by phone, through Zoom or other online methods, or simply deciding cases on the pleadings and not requiring them to come into court.
Okay. Mr. Callahan, what have been the most effective methods in recent years for improving court procedures for efficiency, and what other methods would you suggest?
Well, a couple of things. I mean, one is the continued use of alternative dispute resolution. When I was on the court, I worked very hard with Richard McMonigle, who was the administrative judge at that time, to implement Local Rule 21-2, which is to provide civil mediation services to litigants that are before the court to try to reach a peaceful outcome without the cost of litigation. On the criminal side, what we've seen over the years is the increase in specialized court in our community. There was a time that 71% of the jail population involved mentally ill and dually diagnosed people with drug addiction. So I worked with Judge Griffin at that time, this is some time ago, where we started the mental health docket. It's been followed by the drug court, by domestic relations and other specialty courts, which have dealt effectively with different populations.
Okay, thank you.
I would agree with much of that.
Yes.
Thank you.
Okay. Changing gears a little bit, Mr. Callahan, how do you deal with difficult people, including peers, lawyers, clients, or litigants? And discuss this, if you will, in the context of being a judge.
Well, this is a perennial problem in the court system on a couple different levels. One is the difficult defendant. I mean, it's a question that we have dealt with at judicial seminars, where you get somebody that's a criminal defendant that is unhappy and unhappy with his lawyers, unhappy with the system, and wants to throw as many cogs into the system as you can. And I think the only way to deal with that is to give the guy or the person that's charged with access to the record and provide them good counsel. On the civil side, I'd say 5% of the civil docket at any given moment is what I call red hot litigation, where people hate each other with passion. and you just have to deal with it as the best you can with calmness and with dispassion and with even-handedness. And, God willing, peace will prevail in the final analysis.
Okay, thank you. Mr. Vodrey,
I think
deal with difficult people, including
certainly.
lawyers.
Certainly, and I have. We, from time to time, do have very angry people, very upset people. People take these cases very seriously, even where the stakes might be relatively small. We had a legendary case once where somebody sued over a bad donut. The donut cost them maybe $3 and the filing fee was $27, but it was the principle of the thing. They were entitled to the day in court and they should get that day in court. But some people get very angry over relatively small issues. Some people get very angry over very big issues. Every time you deal with them, it has to be with patience, with understanding, with respect, treating them with the dignity that they might not really be deserving right at that moment, but you have to remind themselves that they do, and it's up to you as a judicial officer to keep your cool and to handle the case so that even if they disagree with your eventual decision, they will know once they calm down a bit that justice was done, that they were treated fairly and impartially, even if they didn't like the process, didn't want to be in court, and might not even like the result, but you will have given them their day in court as they were entitled to and treated them with that respect and dignity.
Okay, thank you. And now, Mr. Vodrey, you are first up for the next question. What qualities most impressed you in judges before whom you have appeared as a practicing attorney, and which of those qualities have you worked hardest to emulate?
Another great question. I was admitted to the bar in 1992. I'm a proud graduate of Oberlin College, where I still go back to teach a course in legal advocacy and Case Western Law School. And since being admitted to the bar in 1992 as a lawyer in private practice, as a lawyer with legal aid, an assistant county prosecutor appointed by the late Stephanie Tubbs Jones, and now as a magistrate, I've seen some great judging. I've seen some not so good judging. And sometimes you can draw even better lessons from that than a judge who is just so good that you really can't nitpick and say, well, I wish they'd done that. I wish they weren't like that, and so forth. But I think the absolutely bedrock quality you need is integrity. You can be very smart, but if you're unreliable or slow or inefficient or, God forbid, corrupt, then it counts for nothing. And integrity is an absolutely vital quality of any judge or magistrate. I've been honored by how many endorsements I've had from U.S. Senator Sherrod Brown, Congresswoman Marcia Fudge, 7 unions, GPAC and FinPAC, both keenly interested in criminal justice reform. And they see, I think, that I am a person of integrity and that I would bring those skills, those qualities to the court as a judge.
Okay, thank you. And Mr. Callahan, what qualities most impressed you in the judges before whom you appeared as a practicing attorney, and which of these qualities do you work to emulate? Well,
when I first came on the bench, Judge James J. Sweeney was the administrative judge at that point, and he was a very calming influence. He had infinite amount of patience. There's 2 ways you can react to the responsibilities of being a judge. One is to kind of grit your teeth and fight and fight and fight, and the other is to take a deep breath and listen closely and be very, very slow to anger. And I think that's a very important quality. Good judges are well prepared. Good judges have read the cases that litigants have brought to them in brief form. They're polite and civil to the parties. They bring them in frequently in an effort to resolve disputes or to deal with discovery or other problems that occur during the course of litigation. So I think those are the qualities that make a good judge.
okay, thank you. I see, in addition to our timekeeper's stop, I see that the time for this forum has elapsed. So on behalf of our debate sponsors, the Cleveland Metropolitan Bar Association, judgeforyourself.com, and the League of Women Voters of Greater Cleveland, and on behalf of the voters who need to make the important choice thank you very much for participating in this forum. For
Thank you.
audience members, our next forum will begin at 1 o'clock. Thank you.
Thank you. I'm very
for having
grateful.
us. Appreciate it.